Hi, and welcome back to Generative AI and the Delivery of Legal Services. This is going to be a recap module. So we're going to see the big picture over chapters 6 through 9, and so we're going to go through that at a very high level. It is not going to include everything in each chapter, but just touch on some of the main concepts. So first, prompt engineering and RAG, then the impact of AI on the business and practice of law, followed by ethics, and then finally rethinking access to justice and pro bono. So prompt engineering in RAG, we learned about naive prompts, where if you don't provide the AI with enough information, it will not know what to do, just like a person would. Informed prompts, by contrast, provide great levels of detail that aid you in understanding the situation, and also likewise for the AI to understand what you're trying to accomplish by providing much more detail, in this example about drafting a lease. And suffice it to say, prompt engineering is just good communication. Just like you would communicate with a human being, you want to communicate well with an AI. So one of the mistakes that you could make is giving it poor direction. Tell me about the law is not really something you would tell a law professor, now would you? But if you become much more detailed, then you could focus in on the specific thing that you need to know and that they can teach you. Failure to provide examples is another mistake. The examples that you give all actually direct the AI in providing you with something according to your expectations. So if it's a legal memo and you give it an example of a legal memo, then it's going to know what what you want and deliver it within that format, which ties us into the next mistake. Draft a legal memo and providing it with an actual format and breakdown of IRAC, for example, issue, rule, application, conclusion. By doing that, by providing it with examples, format, and context, you're going to get a much better, output than you ever would have by just a general request. And that's one of the reasons why you never want to finish with a naive prompt. You may start with one, and it is okay. I've done it. Many people have done it. It's all been what we've started with, a naive prompt. You just want to build on that and get much more comprehensive. And so one way to do that is by utilizing these prompt frameworks. So the framework, like IRAC, is a structure that we use to ensure that we include all the information that we need to get a good output. So the elements that go into it are context, guidance, examples, format, and then some kind of evaluation criteria. Is this a good output or not? So how do we judge that? So one framework is RTF, role task format, where you assign the AI a role, you give it a task, and then you give it a particular format of the output. The pyramid, the reliability pyramid that I put together, at the bottom you have just bare ChatGPT, the consumer version. It's okay. It's actually really amazing compared to 2021 when we didn't have it. Prompts, learning what we just learned about prompt engineering and context and all that good stuff makes it even better, because then you get something that's much more customized for your needs and fits your expectations. Even better than that in terms of reliability is when you use retrieval augmented generation, which we learned about, and tie it to a source of truth, some document that has verifiable facts and information and format and all of that good stuff, and tying that to the AI model. And this is what it looks like when you do that. Essentially, when you ask a question of an AI model that's tied to documents, is that it queries the documents to find the most relevant information. It serves that up to the AI model. It takes chunks out from the source document and says, hey, this is relevant, so is this, and so is this. And then the model actually synthesizes an answer from all of that and then answers your question. So that's what's happening in the background when a retrieval augmented generation system is working. Next, what is the impact that this is having on the industry? Very, very sizable impact. AI adoption in legal professionals generally has been up to 79%. In-house counsel, specifically 86% and 76% for law firms. I'd point out that the latter two are use per week, right? So the frequency is a bit higher there, whereas the 79% was just a general survey about AI use. So there's been wide adoption. AI, it can be used as a force multiplier. So what's the point of that? The point of that is that there's kind of two camps right now, right? There's the substitutional way of viewing AI, and then there's the augmentative way of viewing AI. And so viewing as a force multiplier, you can save time. You can actually bill more because you can take on more clients if you're spending less time per client. And you can automate billable tasks. And you could actually automate a lot of non-billable tasks as well, so that you can spend more time on the billable tasks. So some of the impacts of this as well are that junior tasks, the traditional junior tasks of entry-level work, allows junior lawyers to actually get up to speed more quickly and take on more responsibility. So that's a good output from that. Earlier strategic involvement, but at the same time, senior lawyers need to do a lot more supervision, right? They're not only supervising junior lawyers, but they're also supervising the AI now, or they should be. So we talked about Moravec's paradox, and that basically means that the things that seem hard for humans, analytical, strategic, that good stuff, is actually easier for AI, and vice versa. The stuff that seems easy to us, like sensory perception, motor skills, is harder for AI. But as we saw with Figure, the robot company, and some of the other robot companies worldwide, they're catching up pretty quick. So what to do? Consider alternative fee structures, flat fees. If automation makes things predictable in terms of how long it would take, less time, then you can flat fee that because you know how much it would cost. Subscriptions is another way, so that you have a recurring relationship with your client. You already know what your sunk costs would be on providing services because you can automate most of it. And so turning that into a recurring relationship. Finally, value-based billing is where you price based on the value you're delivering. So there's a certain value for the client. It might be more valuable than the time you would spend on it. And so you get to price it accordingly. Jevons paradox. So Jevons paradox is in a way reassuring because what it says is essentially when you decrease the price of something, you likewise increase its demand. It's something that seems paradoxical because we think that essentially this falls into the robots will replace us theory, that if AI can do our job much more cheaply and quickly, well then AI will do it entirely. But what Jevons paradox suggests is that if we could drive down the cost of legal services, there'll be a greater demand for legal services. And if that's true, there will be more human lawyers that are necessary in the loop to accomplish that. And one of the examples that I gave you was ATMs and bank tellers. So we need to balance efficiency and quality. Basically, we need to balance the AI element and the human element. Most legal professionals believe AI is a force for good, but if you take it too far, obviously, like anything, 96% say you got to draw the line somewhere. Of course, it's dogmatic that you want to verify your outputs. We have way too many cases from judges finding lawyers who don't do that. So I don't want to find any one of my students not verifying their output and reading about you in the newspaper. So please take this to heart. Ethical and regulatory implications of AI in the law. So clearly, and this was a very, very popular subject throughout up until this chapter, and I'm glad that we got to cover it in detail. But 1.1 of the ABA model rules requires us to provide competent legal services as lawyers. 1.6, that we ensure the confidentiality of our clients' information. And 2.1, that we exercise independent judgment. So we'll see how that plays out with AI. One way that it played out in the Schwartz case, the Meta versus Avianca case, famously filed hallucinated cases with a federal court. Well, number one, is Rule 11 enough? And we'll see what that is in a second. But Rule 11 just requires us to be accountable for what we file with the court. Courts went on to require AI disclosure certifications, where you disclose that you're using AI, or that you certify that you didn't use AI, or that they required AI education. There was a whole spectrum of a response to the Schwartz case. Rule 11, though, requires that representations we make to the court, including filings, be truthful, and that we certify when we sign it that it is truthful, that it is not being presented for any frivolous reason. And so, essentially, lawyers are legally accountable and responsible for the truthfulness, accuracy, and non-frivolousness, if that's a word, of our filings. So I think clearly that is enough, because it makes us responsible for all representations, even those that AI helped us to formulate. Technology competence. So baked into Rule 1.1, since I believe 2012, has been a requirement that we stay as lawyers up to speed on innovations in technology. Formal Opinion 512 took that a step further, but also pointed out that it doesn't mean that we need to become a data scientist. We do need to keep up on developments of AI and understand its strengths and weaknesses, like the fact that it could create hallucinations. Client confidentiality. So under 1.6, lawyers are required to make reasonable efforts to ensure client privacy. Not perfect. Not saying that you shouldn't strive for perfection, but we all realize that that's not always achievable. Under 5.12, how do we implement that in an AI world? Well, what we do is we review carefully the terms of service and privacy policy of the AI vendors, AI models that we're using. And if there's any risk of disclosure, we need to inform our clients. And I had pointed out that one risk of exposure is when we actually don't read the terms of service or privacy policy, because we can't possibly know if it is subject to risk. And if we don't know, then we need to disclose. So you want to do a good job of reviewing everything. Rule 1.4, client communications. Need to keep the client informed about what we're doing. Under 512, you don't have to disclose AI use if it's for routine tasks, but if it could materially affect your client's case or reveal sensitive information, it's prudent to let the client know. And I had shared with you that my personal policy, regardless of ethics rules, is that I let my clients know that we're using AI. It's really not a big deal, and I think some clients welcome it, that you're being more efficient and that you have a second set of eyes, even if they're virtual ones, on the work that you're doing, and maybe you could possibly save them some money. But to me, getting it out there, just being transparent about your policies is a winning strategy. Rule 2.1, independent judgment. So you need to exercise independent judgment. It means that there isn't a business manager who's guiding your decisions. It's that is independent from your firm, that is a non-lawyer. It means that lawyers are making decisions based upon their fiduciary responsibility and ethics. So you don't want to delegate that. And so what happens, or what could happen, like in the Schwartz case, is that you delegate that to an AI because you haven't done the job yourself. And so you want to treat these tools, like I've been saying, as a human assistant. What does that mean? Well, human assistants, they make mistakes, just like we do, just like lawyers do too. But when you have an assistant do work, you review it because they may have made a mistake, knowing that you as the lawyer are ultimately responsible for the work product. Practice of law. So the unlawful practice of law is something that gets talked about often when it comes to AI. The actual definition of the practice of law in the ABA model is the application of legal principles and judgment with regard to circumstances or objectives of a person that require knowledge and skill of a person trained in the law. It's a vague rule. Sometimes you'll find state definitions that just specify like all of the various things that lawyers do and say that's the practice of law. There's a question in my mind whether or not it's unconstitutionally vague and also, essentially a violation of free speech and association. But regardless, there are these statutes on the books. I would question whether or not an AI model would be engaged in UPL if it's actually an attorney that put it together and stood behind it. If it's acting independently, it's not a person. This definition requires a person, But still, as licensed attorneys, you need to be careful about this possibility. We also talked about bias, and we looked at bias in the training data. Training data is historical. It's also reflective of our past history and behavior. So naturally, the training data itself might have bias inherent in it. So we need to be careful to look at that and to see if that's the world we want to live in going forward. Because as we know now, AI is of a predictive nature. And so if it's predictive, it's going to make future outputs based on past historical data. And so we need to keep in mind if that's what we want and make decisions about how to modify that. Algorithmic bias is where there's actually bias in the choices in coding and how the actual algorithms in code are affecting the output or outcomes. So it could be that the algorithms have been created, like if it's a trained model, that the trained model is based on faulty training data or biased data. Cognitive bias comes into play when you make the actual selection of which models to use or which algorithms or what code to use, that you might just choose one based upon your own cognitive bias, which might be implicit or explicit, and to be mindful of that. Finally, we touched on rethinking access to justice and pro bono, how you could do that based on AI. And the reason why this is such a dire need is because there is a justice gap. So the justice gap mostly affects low-income and marginalized communities. And what it means is that there's a high volume of civil cases from eviction to debt to family law that go unaddressed every year. A lot of times because people don't even realize that they have a legal problem. And then subsequently because they simply can't afford the cost of having a lawyer help them. So some key statistics are that 92% receive no or inadequate legal help. That's a striking figure, and it's one that's been repeated every year for many years. 74% of low-income households face at least one civil legal problem yearly. And because legal aid is so underfunded, there's many eligible cases that actually get turned away that qualify for help, but there's just not enough capacity in terms of staff attorneys to help. Same thing with pro bono. There's just not enough volunteer attorneys in the world to help. So the strengths of traditional pro bono is that you have highly qualified attorneys volunteering their time when they have time. And the other strength is that it could lead to systemic changes and reform because you have very large firms involved in providing pro bono services, and if they take on one of the causes, they can make a dent. Some of the challenges of traditional pro bono, though, is that, as I implied earlier, it depends on availability when they have time, and when they have time that they're not working on the billable hours they're required to perform every year. And clearly that doesn't allow for scaling to need in any quick manner. Also, because these pro bono attorneys are mostly in urban centers, it doesn't help rural areas and creates these legal deserts. The traditional approach of legal aid is that you have staff attorneys who specialize in different areas, but they're mostly funded by grants, donations, um, and they're chronically underfunded. So because they're chronically underfunded, they have a capacity restriction. And so if they have tens of thousands of people that have legal needs, they can only service what their attorneys can physically provide. Because why? It's a one-to-one relationship. One attorney, one client. How do we change that? Well, one way is by using automation. Doesn't have to be AI specifically. It could just be automation that we use to be able to do more, with less time, because we're using, let's say, automation or AI to draft standard standard pleadings or letters. Somebody, a client answers a few questions, and then we take the answers to those questions and create documents where an attorney is not even needed to do that part of it, but is there obviously to review it and ensure its accuracy and reliability before it's ever filed. Saves a lot of time, can handle more people. Or you could use AI to quickly summarize a large set of documents. It used to be, when I graduated from law school, that there would be essentially a large warehouse of hundreds of junior lawyers reviewing documents out of banker boxes. And I wouldn't wish that on anyone. And nowadays, you don't have to have it that way. You can have AI summarizing documents, and those lawyers, the junior lawyers, could be doing something a lot more interesting. And so the attorneys can focus on client service because a lot of the routine stuff is handled by AI and automation. So you can take on more people and help them. It could also help with one basic task is just intaking clients, getting standard information, filling out preliminary forms. That kind of thing could be either a chatbot on a website that's asking those questions, or it could even be on a phone where an AI voice is asking the same information, gathering it. And we saw one example of that last week, actually, with that AI nurse example. So AI efficiency gains, very popular. 90% of legal aid attorneys reported that using AI increased their productivity, and 75% of them plan to continue using it. Just interesting. Like, if they got a 90% gain, I'm not sure why 100% don't want to continue using it, but it is what it is. So that's the recap. Prompt engineering and RAG, it really levels us up in terms of what we can accomplish with reliable information. It's definitely having an impact on both the business of law, the non-billable stuff, and the practice of law, and is also helping us to, I would argue, create better work product, because we can have a second set of virtual eyes on the work that we do and accomplish even more. We also looked at the ethical and regulatory impact of all of this on what we do and what we need to be mindful of as we practice as lawyers. And finally, rethinking what we can accomplish with access to justice and pro bono using the power of AI. So it was a quick recap, but it covered all of the chapters 6 through 9 that are the subject of your next multiple choice exam. And I wish you the best of luck on that. See you next time.